any mention?
Not the series we're thinking of today.
Lordship, because we require some time to prepare.
No, you're looking very
Slightly
fresh and ready. So we'll take them up.
I'm slightly unprepared because there are 41 matters of the facts.
Slightly
and
unprepared is fine.
I'm praying for a week's time, Lordship, because it has to be done in one shot. I'm unable to, my Lord, go through all the petitions.
You don't need to go through. There's a common theme. It's very
No,
simple.
the dates and the facts and who is having what kind of business. I'm praying for a week's time, my Lord. We'll positively finish it.
I am sorry, Mr. J.
A week's time, my Lord.
Where's your senior colleague?
He's there, my Lord.
You're arguing the matter?
I'm praying for some time.
Positively.
Positively, Lordship. Even on the last occasion I had prayed, so I require some time to prepare, but
What does your opposing counsel feel about that?
that.
I don't feel anything.
I mean, you feel you object or you don't?
I don't feel like objecting right now.
Okay. Just give the numbers.
Only 1 week.
Mr. S. D. submits that due to extreme personal difficulty. Prays that the matter be adjourned for a week.
Till 10.
Prayers allowed. Just after 1 week is.
Till 115, my Lord.
I'll give you more than 1 week. I'll take it to next month.
Positively on the, yes, my Lord.
Listed, where's June? Listed on, I'll give you a 21st June is a solstice, no? Or the longest day or solstice?
I'm not very aware.
You're not aware of solstice?
No, I'm aware, but I don't know whether it's on 21st.
It's equal day and equal night.
Lordship.
Or the longest day?
The longest day.
Longest day. So we'll give 21st.
Very well, my Lord.
Longest day.
Very well, Lordship. Much obliged, Lordship.
Yes, Lordship. I beg him to make a mention of item 19. Should the conducting counsel is indisposed, Lordship.
19?
Yes.
Who's indisposed?
Mr. Paul.
Who's the other side? Mr. Ganguly. Who's appearing for other side? You have taken consent?
In the last dates, they have not appeared, Your Lordship.
Due to indisposition of the senior counsel, this is matter after 2 weeks. Is
Really obliged.
Item number 26, Lordship. This is a dismissal from service matter. I need some time, Lordship, here. 26, Lordship.
2-6.
Yes.
21 matter. 2 weeks, okay. Yes.
Hello, Lordship.
Apply.
Item number 1.
What is this, Mr. Someone?
Please, Lordship, before I move, I just wanted to inform you that usually, Lordship, sometimes didn't take up the matter. Here, page 75, Your Lordship, it's appeared
Lordship
that
had appeared.
earlier
Counsel for the petitioners present.
Not for the
appellants.
petitioners. I don't know these petitioners.
Not for the
I appeared for the
appellants.
state.
For the state. For the state.
There is no problem. That's
What is wrong?
Nothing
That
wrong.
time when I appeared for the state, I think, which
Yes,
matter is
yes.
this?
This is only for the.
It's only
reservation matters.
to apprise the court with regard to what is the revision policy, I think. I remember this matter
Yes,
because especially engaged
Yes.
by the state to.
Yes.
Because at that time, I think there was some problem with the government council. They
Yes.
couldn't put their case forward.
Only for some time. Just because my learned friend was saying that.
So anyway,
But this
this
case
is
was-
matter before you have no.
No,
this
I
matter-
have no problem, Your Lordship.
You have any problem?
I have no problem. I have no problem.
But that thing doesn't concern this
No,
matter,
it
I think.
doesn't
This
concern us.
concern, I
But
go
we
with
thought
your
that
lordship
we
that
should
I-
just bring it to
yes.
your notice, Your Lordship.
Yes. This
Very
case,
good.
What happened actually, this, as per the advertisement, 21/5/2015, Your Lordship, there was a jailer, there's what they have been recruited. After recruitment,
When?
they, in the year of 2015.
15.
There was a recruitment. I have annexed also. The recruitment was done, and after that, some individuals they filed against the selection process, and it was stay, Your Lordship.
Yes.
Then after that stay against the stay order, the order was passed on 19/7/2017, setting aside all the recruitment process. Thereafter, the petitioners and they
appointed.
appeal, and then appeal stayed the order of that single bench, and after that, the entire case finally disposed of, Your Lordship. Entire case, I mean that in the division bench. Then after the disposal of the case, Your Lordship, there is that the grievance of the petitioner hearing now that since they have been recruited in the year of 2015, and then just since there was a case pending, then after now case has been completed over, then I have also put
So
in
what do you want by this present
now,
petition?
Lordship, I will come to that. Now there is some benefit, Lordship, like scheme different, like pensionary promotion, and then some other scheme they have mentioned here, Lordship. But those benefits, service benefits, they are not. They are denying because they said that's a state respondent saying that there is a case is pending. So they are denying because
What case is pending now?
now there
What case is pending?
no case is pending, Your Lordship.
There's no
That's
case
why we have
as of
Then-
now, Your Lordship, because they have most of them have got their relief. So they
All of you have been
withdrawn
appointed,
the-
correct?
that's why.
They are asking for service benefits.
Then why are you filing a petition?
No, Lordship. Now, since I have stated that since there is no case, they are saying that all the benefit of service benefits should be like promotion and other benefits should be given to the petitioner. They have filed in representation. I have annexed in the page 9, annex 9, Your Lordship. They are not relying. Since the case has been completed, it is admitted by my learned friend also. We have already enclosed it. The case, whatever case pending
We'll
before
dispose
them.
it of. What is there in the case?
The representation, Your Lordship.
No, if they're entitled, whatever entitlements, they'll get it
Yes,
as
get-
per the
yes,
terms
yes.
of appointment.
Yes,
What is
Lordship.
there?
So that is why I'm coming before. Since they have denied, they are saying they have not. They are not.
No, they're not. Sometimes they're not well informed. You have to educate them. No? Say that look, this case is over. These are the orders. So that's the thing.
We have already informed here because
Instead of filing representation-
no, in our representation we have detailedly mentioned your annexure page 89, annexure 9. We have enclosed all the court order also, Lordship. In the back side of that we have
Oh, you will be put under the national pension scheme.
national
Yes,
pension
that
scheme,
is-
You want
national certificate promotion allowance, and
And
at the time
the-
of suspension also actually
you were suspended also.
we are suspended just because of that. There was a stay order by some individual. people.
That does matter.
They are asking for subsistence allowance during that period, Lordship.
However, we are not
Then the
insisting
case
on that,
was
but we are
pending.
asking like this kind of service benefit like annual increment, national pension scheme promotion, and other Lordship. So we have when we in our representation we have put it detail
So
everything.
so according
Representation
to
is still pending,
it
Your
deserves
Lordship.
it deserves a petition. Is at your advice you told them, let's go to court. When the matter is so raw, so they just joined service in 17 and you ask them for to be put in a pension scheme. They'll be put on a pension scheme.
It's too early.
What?
No, Your Lordship, because since 2015 we have been recruited.
Now where are we?
2015
It's 5-6
now,
years only. Other writ petitioners, how many of them are there?
74 of them, Your Lordship.
they are all jail staff,
74 writ petitioners.
Lordship, from different staff from the, all
Now before
time.
this court, with a prayer that, where's your prayer?
Great Lordship,
With a prayer that
page 22.
the respondent authorities be directed to grant various service benefits as various benefits including being put under the national pension scheme, consideration of promotion, annual increments and so on. Stop. Next para, Mr. P.T. Sangma submits that the petitioners have been compelled to approach this court in view of the fact that in spite of filing representation, the respondent authorities have taken the stand that there are some writ petitions pending that have prevented them from considering these said representations. Next paragraph, he further submits that there is no impediment to the consideration by respondents in as much as on date there is no litigation or any cases pending with regard to the subject matter. Stop. Next paragraph. MSD Yangi Leonard EAG with MSR Colney for the state respondents submits that the writ petition is not only premature, but without any basis. inasmuch as in the usual course of service and as per the terms of appointment, whatever servant entitlements the petitioners are due to get will be processed and allowed in due course. Stop. Therefore, having heard the counsel of petitioners, for the parties, it appears that the grievance as made out does not warrant any interference or any directions, except that the representation is pending, be looked into and disposed of by the respondents as to the entitlements of the individual petitioners. So with the above noted directions, matter stands closed and disposed of. At this stage, you're coming for pension and all.
Oblige you.
Item number 2.
Not promotion, another service benefit also.
Promotion. Are you due for promotion after 5 years?
No, it seems they're already others said they're getting.
May it please, Lordship. Lordship, here the petitioner's father had been the owner of some plot of lands, Lordship, measuring around 52 bighas, Lordship. Some plots of land measuring around 52 bighas, Lordship. The petitioner
52 bighas.
50 bighas, Lord. The petitioner's father died in 1998, Lordship, leaving behind the petitioner and the respondent number 8. Petitioner and the respondent number 8, Lordship. There is no family issue, Lordship.
There is no female issue.
Yes, Lordship. So, as per the law of succession, Lordship, as per the law, Hindu law of succession inheritance, that the property should be devolved equally upon the petitioner and the respondent number 2, because there are 2 brothers, Lordship.
Respondent number 8.
Yes, Lordship. Then 2006, Lordship, 2004, Lordship, then he approached to the Revenue Court, Lordship, for mutation and apportionment of the property between the petitioner and the respondent number 8, Lordship.
Yes.
Then the Revenue Court has allowed that since we are 2 brothers, then we should get the property in equal distribution, Lordship. Then direction was given. Then when nothing was happened, then again I went to the Revenue Court, Lordship, in 2012, Lordship. Then in 2015, then upheld the order of the previous order and direction is given to mutate the land.
2006 you got order.
Yes, Lordship.
Then after nothing happened.
No, Lordship.
Till after you went after 9 years.
2012, Lordship. I went, then order was passed in 2015, Lordship.
What does the order say?
Direction is given to mutate the land. That is at page, Lordship, 24, Lordship.
24.
24, Lordship.
Yes.
The last part, Lordship. So his objection, because the respondent number 8 raised the objection saying that the father had left one will, Lordship.
There's no connected to other matter.
My lord, this is the matter which Mr. B. Deb had been arguing, where he was required to take instructions, my lord, as to what happened with regards to the will. So this is, my lord, the same petition.
Same property?
Yes.
Twice.
No. See. One thing was that is it the other case where the court had queried Mr. Depp as why he didn't go for appropriate if the will is there?
Appropriate, yes, there is a will, but as
Now, is this number 8 the petitioner of the other case?
Yes, my lord.
Then we'll hear them together. We should have alerted the court to this. Only that I saw this will business, it just struck my mind.
because I am not aware with that he has approached. Earlier also he approached
You're not
twice. Twice he approached, withdrawn the case.
So you're both brothers, you don't know.
No, he has approached that issue, that matter is pending, that he has filed
What
again.
WPC number is it?
My lord, that is WPC 83, my lord. 83 of 2023. 83.
83 of 23.
23.
When is it due to be listed?
That is on 22nd, lordship.
This is matter on 22nd along with
83.
WPC 83 of 2023. Very good, yes. Right, Ms. S. Sheikh, the counsel petitioner, Mr. S. Debb's present on behalf of the respondents.
1 to 5, my lord.
Respondent for the respondent, stop. As it has been informed that another connected writ petition that there exists another petition filed by respondent number 8, wherein the petitioner has an issue with
The same orders, my lord.
Yes, sir.
He doesn't want the joint patta, he wants the joint. That is the...
No. And the other case, I remember that Mr. Depp says that he has a will, but that will has never been produced or...
It was not accepted or something like that.
Yes, true. The order said
Listen
so.
together.
Highly
Number
honourable.
3.
Authorised court.
Third round, Mr. Second round. Yes.
Here, Milord, we are assailing the DPC, Milord, and
DPC?
the minutes and the recommendations of the DPC. Now, if I can take your Lordship, Milord, to the paragraph number 10, Milord, in the petition.
Ten.
10.
Yes.
Now, in the previous judgment, Milord, this was the observation and the direction, that with regard to promotion to the post of chemist, as the petitioner is qualified in all respects for consideration thereof, the same is to be taken into account by the respondent number 1 to 4, and his name shall be accordingly considered as and when the departmental promotion committee sits. So, Milord, this, that the petitioner is qualified in all respects, Milord, that was on the basis of an undertaking of the government. I mean, it was considered before this Honorable High Court. Milord, thereafter, Milord, the DPC was not convened, so we came with a fresh writ petition, and in that, Milord, a time limit was fixed of 2 months. And thereafter, Milord, if your Lordship comes to para 11 lower part, Milord, however, it is directed
Yes.
that the exercise should be completed within a period of 2 months from the date of receipt of a certified copy of this order, and any further unrequested relief afforded to the petitioner should be in accordance with law. Thereafter, Milord, this was not done within the period of 2 months, so we approached with a contempt petition, Milord. So, in that contempt petition, an affidavit has been filed, Milord, that after the notice of contempt was issued, thereafter, Milord, an affidavit has been filed bringing on record the proceedings of the DPC, which was held on the 14th of March this year, Milord. So, Milord, by being aggrieved by that DPC's
Now you're
proceedings,
back
and
here.
now we are challenging the DPC.
Why are you aggrieved, Mr. Chakravarti?
A number of grounds has been taken,
It's
Milord.
been rejected, your consideration. They have not
They have not considered also, Milord. The DPC has found found my candidature to be not proper, Milord, and they have referred it back to the government. Milord, a number of persons were referred for consideration, but the DPC found it proper not to consider. Now, Milord, as it so happened, the chairman of the DPC was the same person who was under notice of contempt. So he changed his garb, Milord, from the... That is what we are... That is one of the grounds taken by us, Milord. That he has when he becomes the chairman of the DPC, what he could not do as the secretary, now he has done that, and the other members also. Now, Milord, but the main ground which we have taken, the first ground, Milord, is that there are no rules as such under which the DPC is to be constituted. Now, the admitted position is that there are certain draft rules which they have been following. Now, in the draft rules, there is a specific provision regarding the DPC, that is at Rule 8. It lays down that the DPC is to be headed by the Chief Secretary. It's for a gazetted post, so the Chief Secretary is to head but that was never followed. So that is the first ground which we have taken, first prominent ground. Otherwise, Milord, the power...
Where's the recommendation DPC, Mr. Chakravarti?
That is the last.
Yes, let's go there. Yes.
My Lord.
What does it say in the end? Not recommended.
Malan, at page, what page is this? Annexure 11, Milan, the last one.
Okay, where is it? Yes. The committee approves all relevant papers. Oh,
Milan, if your lordship comes to the subsequent page, Milan, after carefully scrutinizing,
yes.
Milan, after carefully scrutinizing all the papers and service records of the officers concerned, following are the observations of the committee members. Number 1, Mr. M. Nongrum was initially appointed as laboratory assistant on
Welcome to our last part. Health department, didn't remember his name. He didn't have the qualifications.
Malan.
Then the
So
next one.
they have found none of them were qualified, but with regard
Come to
to
the petitioner.
petition is the last one, Milan.
Yes.
Milan, on the last page, Milan, the committee perused all the relevant papers
Yes.
in his service records and observed that since he was initially appointed on officiating basis, he should have been regularized by the Meghalaya Public Service Commission or District Selection Commission, as the case may be, as per the relevant government office memorandum issued by the Personnel and AR Department. Only the Cabinet could approve for regularization of ad hoc appointment. Since his initial appointment is irregular per se, his subsequent promotion also stands irregular. Now that is their finding, Miller. Now, in my respectful submission, Miller, this is not within the purview of the Departmental Promotion Committee, Miller. We have taken the stand, Miller. Departmental Commission.
Let them take instructions, because the thing is that now, when was he appointed initially? Was it 2003? Now, was this matter was never taken into consideration that he was not regularized?
He was on
Regularized and all that happened.
ad hoc basis only since then.
It
Although
happened.
he was
he didn't have
promoted
answer.
also, I may be allowed to take instructions on this. Your Lordship. Yeah, because I'll come with a proper affidavit after.
Come probably after it, yes, because it's very strange.
In the meantime, we have made a prayer for stay of this.
No, there's no promotion, so there's
Yes,
no.
Yes, nobody
But
was
Mr.
recommended,
S.
yeah.
Vati, learned senior counsel assisted by MS Islam for the petitioner, issue notice. MS T. Young Ilan AG with MS R. Conley, present, and accept notice on behalf of all the respondents.
Yes, Your Lordship.
All government.
But why you made 5 and
Oh, this is yes, in person, personal.
in person? Why you made in person? P. Hujon?
Well, these two are members of the DPC, Milord.
Or they're not official representatives.
No, they were made they're from the particular departments, but in person they were made members of the DPC.
No, but in the official capacity, Your Lordship, they were not, in their private capacity, they were not
Yeah, we'll
appointed
leave
in the
that.
members of the DPC.
Let them accept notice on behalf of respondents. Just after 3 weeks for affidavit, please.
Item number 4.
Right. Bless you.
Yes, Mr. Sheikh.
Lordship, here the petitioner's husband was a retired BSF constable, Lordship, and he retired on 31st 3 to 1985, Lordship. Then, Lordship, his wife, first wife died. Subsequently, he married to the petitioner, Lordship. And the pensioner also died later on, Lordship. Now the only thing is that I want that pension should be transferred in my name, so I put up an representation before the respondent authorities.
Why? Not second wife, there's no BSF rule allows for that
Yes,
after post-retirement
Yes.
spouse. Mr. Dr. Mozika?
My lord, here what happened, my lord, we don't have any information that he
About
ever
second
married.
marriage.
It appears that he married at the age of around 80 years, my lord.
Is there any harm in a man getting married 80 years?
But, my lord, I'm not saying that, my lord. But at least we don't have any information, no intimation to us that he remarried. And he died only recently, 2020, my lord.
So when he
Now-
retired,
now
when he retired 1985, how old was he?
So retired in 85, he died in 2020.
So 85, what's the retirement age? 58 or 60?
60.
60 for constable?
No, Lordship, because
Can it be?
No, he took voluntary retirement. my lord.
When did he retire?
His date
What
of
was the
birth-
age when he retired?
Lordship, his date of birth is 1944, Lordship.
44.
Yes, 44.
Okay.
Then he died
No, then
on
Dr. Mozika, he
2020.
took Jerry when he's 41. If he's born 44 and he retired in 85, he was 41 when he took Jerry.
He remarried in 2017, my lord.
Yeah, no, he married in
Remarried in 2017. my lord.
No, Lordship,
2004.
2004, Lordship.
The certificate of marriage dated 12/12/2017.
But there can be a post recognition.
Sir, made it one. This is the certificate only issued to page number 14.
I'll file an affidavit, my lord.
Yeah. It is very believable. If he retired at 41, he got married 2004 at 20, but he was not even 80 years old. Not married 80 years, he died at 80 years old. Heard Mr. S.A.
Marriage
Sheikh,
certificate of 2017.
doesn't matter. Heard Mr. S.A. Sheikh, counsel petitioner, issue notice. Dr. N. Mozika will also. His pen accept notice on behalf of all the respondents. Oh no, on behalf of 1, 2, and 3 for the state. Number 4. For the state. You're a panel advocate. What's your name? Mr. Impala, Leonard G. is present and accept on behalf of 4. As such, no further notice called for. List the matter after 4 weeks.
File.
Item number 5.
Please, Lord.
Yes.
So this is the second time we are coming before this honorable court, my lord, for essentially praying for
When is the
disposal.
first time? What order was passed the first time?
Lordship, it was for disposing of my representation, my lord. The first time, my lord, it was unfortunately dismissed because the other documents by which we had tried to, my lord, bring about the history of as to why we have filed that petition were those RTIs were filed by some other person, my lord. So now again we have filed RTIs on our own name, and as well as,
Okay.
my lord, the details
What's
of
your
the
case?
Lordship, the case is that the petitioner is aggrieved by the lack of clarity, my lord, as to whether the state job reservation policy was extended to higher and technical education institutes. The cause of action arose, my lord, when his relative, we have mentioned all those in this petition, Lordship, he had, after completing his Lordship, his education in Department of Zoology in Nehu, he applied for the B.Ed, Lordship, at Tura PGT College, Lordship. The merit list was issued in a manner, there was no official notification as to whether the job reservation would be applicable or not. Either ways, he applied, Lordship. He was not given the appointment,
No, in this Tutra PGT college means for B.Ed.
Lordship.
Okay, then
So he had applied, Lordship. The select list came out, having 20 out of the 25 seats which were available, 8 were given to Khasi Jaintia, my lord, and the remaining were all given to the Garo community. As well as majority of the waiting list, my lord, was belonging to the Garo tribe. So essentially, my lord, he filed a representation to the respondents asking for a clarification as to whether it is, because as per all the notifications which are there, my lord, there is no notification which extends this job reservation policy for the purpose of admissions into higher and technical educations of the state.
okay.
That grey area remains, Lordship, and that is why he had filed a representation saying that kindly give me a clarification as to whether you're extending or is it not extended, is there any notification
For the higher technical education within the state,
Within the
not
state.
allotment of seats to others.
within the
Okay.
state for the tribal communities of the state.
Yes.
So that representation has not been, my lord, disposed of, and as a result, my lord, time and again he has applied. Even on the earlier occasion he has applied, but because of any clarity as to whether the job reservation policy is applicable or not, his admissions are getting hampered, Lordship. That is my case, Lordship.
Now you see 25 seats were there.
Yes, my lord.
25 seats and 8 seats have been given to Khasi Jaintia.
Lordship.
That means 8 seats will go to Garos.
No, my lord. The 17 seats go to
There were no other open seats, nothing.
No, nothing specified, my lord. Even in fact, in the merit list.
So even
also,
whether reservation policy is applied or not, that's not clear.
no, my lord. In fact,
Because if you're looking at 25, you're looking at 25, you're looking at 20-point roster also, that means 8, 8, 16,
yes, lordship.
and 4,
Lordship.
3 for open and 1 for like other tribes.
Lordship. But it is not clear because there is no notification or any office memorandum or anything, my lord, to show that this has been extended.
No,
In
but
fact,
then that you mean to say that this, like you are insisting that reservation should be.
no, I'm insisting for a
Then-
clarification, my lord, so that I can apply as per the job reservation, as per the reservation, or on merit without the reservation, my lord, because there is no clarification, lordship.
Yes, Mr. Shulai.
May it please your lordship. Lordship, first I would like to contend that the writ petition is barred by the principle of res judicata, your lordship, because earlier writ petition has been.
No, skip the technicalities. Come to
No,
the
your
meat of the
lordship,
matter.
kindly come to the order, your lordship. That is at page 114. In that earlier writ petition, your lordship, he has sought for disposing the representation dated 19 December 2022. So also here in the present proceeding also, your lordship, the same relief has claimed.
No. Has the representation been disposed of?
No, my lord. This was
In
because,
the
my
earlier
lord, the
petition has sought for that, your lordship.
No, that one was not the.
Documents were denied upon
He didn't demonstrate which manner they aggrieved.
Yes, lordship.
But in this case, if the case is that, like, we can overlook the shortcomings also if they had applied for an institute where they have 25 seats. And where's the list?
If that be, if
Let's
that
see the
be-
list.
we don't have, my lord, in the,
Where's the merit list?
that list is not because it was put online, my lord. That was sometime
His
in
prayer
May.
is for a simple disposal of that
for a
representation, your
clarification.
lordship.
Otherwise, those facts and which college, when he has applied, those are all, my lord.
It is disposal of Mr.
Lordship,
Because
so-
this
so
point,
far-
this
so
point
far
is
that
quite relevant
disposal,
because
Lordship,
even in the assembly
whether in higher technical institutions within the state, what is the manner of admission?
Lordship, I
How is
have
it done?
a small submission, your lordship.
Yes.
Lordship, now I'm asking to myself, who is he? Kindly come to paragraph 9, your lordship, of the writ petition. He said in first paragraph, your lordship, that the petitioner relative Shri Laurent Khar, your lordship. Why this person is the aggrieved person, your lordship? He's not the writ petitioner is not an aggrieved person, your lordship. Laurent Khar should be the aggrieved person. He should come before your lordship seeking a relief, your lordship.
I have explained in paragraph 2, my lord, that why he has himself not come and why the.
Doesn't matter, there's a larger issue involved, Mr. Shulai.
Lordship,
At least,
what
least.
he has, your lordship?
No. You can't just shut him down on a point, on a technicality. Now, what has been brought to the notice of the court, that whatever it is, two boys, two of them, right?
Lordship.
They have applied, and they were denied admission. So, do you just want to know the file representation is why, on what basis
My
does the
humble
name
and
not
respectful
appear?
submission, lordship, that Laurent Khar, your lordship, who is his the petitioner relative, should have come, your lordship. He should have come.
Maybe he doesn't come for other reasons.
He should have come, your lordship.
The petitioner is taking care. I have stated in paragraph 2
What
also, my
prevents
lord.
his having a petitioner in a case of academic admission, your lordship? Then, your lordship, kindly come to the representation. That is at page 111, your lordship, annex 10, your lordship. Then, lordship, I'll take your lordship to page 113. Lordship, what the relief which he has claimed, your lordship? In view of the above fact, the undersigned urge upon your court office to take necessary steps in ensuring that the present job reservation policy be extended for
Take down, yes.
also by introduction of a cabinet.
Mr. S. Dale and counsel the petitioner. Stop. Next, the grievance as put up is with regard to the uncertainty of the applicability of the reservation policy of the state of Meghalaya in higher technical institutions
For admissions, my lord.
for admission to higher technical institutions within the state itself. Stop. The case as put up by the petitioner, who is here on behalf of two of his relatives who had applied for the said post for admission in
My lord, College of Teacher Education.
in College of Teacher Education.
Yeah.
Where?
Tura, lord.
Tura. Tom, no? But there being no clarity as regards the applicability of the resident policy and no clarifications and no clarifications also forthcoming from the respondents is before this court by the instant writ petition. Stop. Next paragraph. Mr. N.D. Shulai, Learned Counsel, Learned AAG with so-and-so has raised preliminary objections challenging the locus of the writ petitioner and has also submitted that the instant petition is barred by the principles res judicata, inasmuch as on an earlier occasion, where's that order?
Lordship, that order will find at page
114.
114, Your Lordship.
On an earlier occasion, this court was pleased to dismiss the writ petition on similar grounds. Stop. Stop. He therefore submits that similar treatment should be meted out to the instant writ petition and the same should be dismissed. So, next paragraph. I've heard and counsel for the parties, though certain doubts still remain as to the locus of the writ petitioner, but the issue raised attained some importance with regard to the two persons named in the writ petition. Who are still seeking answers to the manner of admission into the state's higher technical institutions. Next paragraph. In the earlier proceeding, that is WPC 60/2023, this court had dismissed the same by observing as hereunder. This court, by order dated 23/3/2023, had dismissed the same by observing as hereunder. Reproduce order. Stop. Stop looking into the next one. Looking at the facts presently. Looking at the facts presently and the issues as raised, notwithstanding the issue of locus, the respondents are directed to address the representation dated 19/12/2022, which appears Annexure 10 of the petition, so as to clear the air with regard to this issue. The same shall be completed in a period of 2 months from today. Stop. Next paragraph. Writ petition to the extent indicated, allowed to the extent indicated above and disposed of. Obliged, Your Lord.
Much obliged, Lordship.
Item number 6.
My lord, petitioner, my lord, herein he is the ex-MLA. My lord, he was elected in the year 2013.
Ex-MLA?
Yes, my lord. Elected in the year 2013 to be being a member of the Legislative Assembly of Meghalaya, my lord. And he has served for the complete term of 5 years. And my lord, thereafter he contested the election again in the year 2018. He my lord did not win. But in the year 2021, my lord, he contested for the MDC and then he won the election. Now, my lord, after he...
20?
21, my lord.
21. Now he's still sitting in office?
Sitting in office as an MDC, my lord. Now, my lord, after he completed his term as an MLA, my lord, in the year 2018, he started receiving his pension. But that he received only till April, my lord, 2021. Thereafter, my lord, his entire pension amount has been stopped, my lord. And moreover, my lord,
what is the scheme operating with regard to MLA? Is one term MLA?
One term MLA, my lord. And he's also entitled for other allowances, my lord. That is also not been given, my lord.
Under what scheme are they paid pension?
My lord, they are given under the...
That means pension for life. If you win once,
Yes.
5 years for life.
Yes, my lord. They are entitled for the pension amount. And even in any other states also, my lord.
You paid how much? 20,000?
My lord, I was receiving 30,000 as an pension, my lord, as an MLA, ex-MLA. And now, my lord, being an MDC, my lord, I am receiving only 23,500, my lord.
As pay?
As a pay, my lord. Now, my lord, pension being not a bounty, the state is bound to pay this amount, my lord. They cannot hold it.
No, show the scheme. Where is it?
I tried to
get the scheme.
Get the
then how can you come with
of the scheme,
a half-cooked writ petition?
Right. Now, my lord, it is not available. The gazetted notification.
How can it be available? Then you wonder under what provisions are you claiming a pension?
My lord, the act, I am aware of the act, my lord. But I tried to get a copy from the internet, my lord. That is also not available. The complete act is not available, my lord.
You know the rules? What are the rules governing this for MLAs?
Lordship, I also tried to get a copy from the internet. I could not.
It's not available. I went to the printing and stationery also, my lord.
I'm appearing for 1 and 2, my lord.
Mr. N. Sincon, third Mr. N. Sincon, then counsel with the petitioner. At the outset, it appears that for petitioner MS NG Shilla Sim advocates present on behalf of the respondents. At the outset, noted that certain materials necessary for which are absolutely necessary for proper adjudication of the matter are missing. Ms. N. Sincon permitted 2 weeks' time to obtain the same and file by affidavit. And state government advocate also to undertake similar exercise. Number 3, but that will come later then. Yes. No notice for number 3 at this stage. Yeah.
Much obliged, my lord.
7. Item 7.
This matter pertains to compassionate appointment with
which department?
Department of Botanical Survey of India.
Your scheme is in existence?
There is, my lord.
Where's the scheme? You annexed it?
Not annexed.
What is this?
My lord, may kindly see. In fact, what happened in this matter, my lord, the petitioner's father, who had about 15 years of service left with
Fine,
him.
well and good. The thing is that if you're claiming something under a scheme, at least annex a scheme so the court can appreciate whether you come within the, the zone of consideration for grant of compassionate appointment.
One notification, my lord, which is at page 41. Will clarify, my lord, the scheme is still in existence.
No, schemes will remain, but we have to see the scheme, correct?
I'm really sorry, my lord, I didn't annex it.
Why didn't you annex it?
Sorry, my lord, due to oversight, I didn't file it, my lord. My lord may allow, I'll file by way of an affidavit.
Mr. S. Thapa prays that he may be allowed to file actually affidavit bring on record the scheme of compassionate appointment of the Botanical Department of Botanical Survey of India. This is matter after 3 days.
Well, the matters would, I think, go to CAT, my lord. It's a CAT matter, my lord.
Let them bring it on for have instructions.
Item number 8.
See, if you bring half-cooked stuff, like, you're bound to get indigestion.
Here, my only grievance is, even though I have made a representation, there ought to have been some kind of a reply.
Even then, why don't you look? You should not look for representation. Look for final relief from the court. This for representation. By the time you using the court as a post office, that like you post it here and like forward it there. That's not the duty of the court actually. Yes.
Lordship, this matter I like to withdraw, Your Lordship. This number 8.
Why? What happened?
New development, Your Lordship. This parent village are not willing to take, so they're changing.
I have a prayer and a suggestion. That is regarding those 30 families who don't want to be either with the parent village or with the new created village. I have a suggestion, Your Lordship. This matter can be closed here and the matter referred to.
Yes.
And we will decide.
Yes, I'll take down Mr. B. Karyam. Mr. B. Karyam.
You want to withdraw the case?
Yes. I want to withdraw. We will send it there. You decide. Because it's just it's a question. Mr. Kanta, the question of doing justice also. Do the High Court have power, Article 142, to complete justice? But I think a court sits to do justice, whatever it is. Because the grievance is very sad. I mean, what they've put. They're neither accepting them, nor the new village accepting them, nor the old village accepting them. That's correct.
Yes.
So where will they go? And then what will happen to the schemes? What will happen to the 100 days?
My duty on.
Yeah. You're happy to put them under your wing again?
No,
you're not happy.
They are very much happy. They are not happy with us. They are okay with the 30.
Now we do one thing, Mr. B. Karyam, please may be allowed to withdraw the petition in order to pursue an alternate remedy before other authorities such as the district council, HDC stuff. But it is allowed matters not withdrawn with liberty to the petitioners to take recourse to alternate remedy.
I was under the impression that the council want to withdraw.
Item number 9.
Shall I require
yes,
2 more weeks time?
2
more weeks time to file my rejoinder.
If there are no appeal and council petition, please once allowed 2 weeks for a time to file rejoinder. Just thereafter and so on.
10.
Please, Lordship, I beg, please allow 2 weeks time to file our affidavit.
1 second, Mr. Rahman. You're for 7?
Yes, Your Lordship.
For 7?
Yes, Your Lordship.
Similarly, Your Lordship, for the state respondent want to file?
M. Rahman, what about number 6?
We are still awaiting report from the post office.
Mr. N. Basumatari, counsel for the petitioner, submits that they are still awaiting the status of service on spot number 6. He prays for and allowed 2 weeks for a time to obtain status and to file affidavit of service if necessary. Stop. MS Ailingwal, GA and MS M. Rahman, correct? For respondents 1, 2, 5 and 7, pray for and allowed 2 weeks time to file affidavit. List thereafter and so on.
11.
Please, Your Lordship, we have received, Your Lordship, the affidavit filed by the state respondent. We pray for some time to file for the rejoinder.
Your name?
A. Harmandai.
MS A. Harmandai for the petitioner. Pray for 3 weeks to file rejoinder affidavit after the state respondents. Just thereafter.
12.
This becomes, we'll close it.
Well, if Your Lordship...
Contempt, so you can all re-agitate it, because now the bigger issue is gone.
Only one aspect, yes. Only one aspect. We have raised certain issues, proper affidavit has not come. Only the minutes have been recorded. Now, we have, in our rejoinder, we have pointed out in the minutes what are the defects. And our submission is that this has led to more further contempt. Milord, I would only humbly submit, Milord, let them come up with a proper affidavit at least, so that, Milord, your Lordship may examine all the aspects. Milord, now, Milord, what will happen?
They'll get emboldened, you mean?
Sorry, Milord. Milord, whether emboldened or not, Milord,
You get
when
emboldened
somebody is under notice of contempt, at least let them properly respond, Milord.
No, you
That
see,
is-
the
that
only
is,
thing,
Milord,
see,
it's a question of
just
dignity of the court, Milord.
compress the scope of the order. But that is the alleged violation. If that there's an order saying that whole DPC within a certain period. Now your contempt is centered around that. So whatever is actual issues, contempt between the court and the
Well, that is, of course,
which is alleged not been held, it's already been conducted, and also on a subsequent challenge in a different interpretation. Nothing survives for consideration at this stage in this contempt matter, and the same is closed.
Milord, issues might come up later.
No, that you can, you're always free to agitate.
Milord.
13.
Milord, if your Lordship gives an observation, I'm free to agitate if the need arises.
Yes, incidental and other attendant issues. The petitioners are at liberty to agitate independent, incidental and other attendant issues in the pending writ petition. Yes.
Please, Your Lordship. Lordship, for the third time the notice was sent. This time it was on the second occasion also it was sent through the SP Tura, and the third occasion also it was sent through SP Tura.
He received it.
But then the report has come to this honorable court that the notice was received at Tura police station on 25th of April, whereas the matter was fixed before this honorable court on 24th April. So instead of serving the notice on the respondent, they have returned the notice along with the petition. Sir, it's creating unnecessary.
No, it's creating because these people, you can't blame them. They're treating it like the lower court. You understand? For under fixing the next order. This court, by order dated 24/4/2023, had directed for service of notice through the Superintendent of Police, West Gargils Tura, as the said respondent was on commuted leave and was to join only in mid-April. Stop. A report has been received today that as the matter is moving on 15 May.
25th April they received the notice, yet they did not serve it on the respondent and sending it here in May.
When we abandoned. Problem? As a report has been received today that from Seminole Police that the notice will not be served as the date. I don't understand this. Were received late, white so and so, date so and so, and which could not be served on 24/4. There is a direction to be served on 24/4 itself.
My lord, what has happened is on 24th.
Oh yes, yes, list on 24/4.
It was listed on 24/4.
Right.
That is why.
Yes, Tom. As it was received only on 25/4/2023, but that the date fixed by the court was on 24/4/2023, and such had lapsed. Stop. Request has been made by the Seminole Police that they may be allowed to issue this to to serve the notice. Stop. On perusal of the note, it appears that there is some misunderstanding with regard to the manner of service of notice. The duty of the civil police is only to serve the notice on the said respondent and to file a report accordingly without taking notice of the fixation of the date before this court. They thought that since it's fixed on 24th and they got a notice 25th, they could not serve it.
Tura police station received on 25th.
Yes.
So, my lord, this same petition can be...
Yes, the same one is they serve it, yes.
14.
Obliged.
This is that matter pertaining to acquisition of land in Ribhoi Malab by the BSF Malab. So the respondents were supposed to bring on report. In fact, on the point of law, my lord, they were supposed to.
Lordship, on the other occasion, what is noticed that they wanted that the letter dated 8/3.
1 second.
Sorry. They have filed a limited writ petition.
Page number 79 of the
79.
petition.
They wanted to. They are challenging Annexure 10.
79.
Yes, and consequent to this, the Deputy Commissioner had written to the Executive Committee by way of letter dated 17 February 2021 at page 77. Consequence to page 79.
77.
The Deputy Commissioner wrote to the District Council, and the District Council, this matter is not so simple, Your Lordship.
No. See, Mr. Kanta, under this new Act 2013, the consent of District Council is necessary now, as per the mandate of the Act, correct? Is that the only hurdle?
Lordship, because Lordship, they are saying that we need to obtain an NOC from the District Council.
That is mandatory now, because occasion of land scheduled areas you'll need a consent.
Now,
NOC.
No, what happened, Your Lordship?
Now, what happened after that?
Consequence to page 77.
I'm some of the details of projects such as area of land, so on and so forth, location for the above project is sent to you, okay, to give consent for the same. Now this is 2021, right? Now it comes to the Deputy Commissioner on the same day, or sorry, the Deputy sends on the same day for your consent. Now what happened after that? Then you send it to the Deputy. What do you say in your reply?
No, I draw your Lordship's attention to...
No, Mr. Kanta, just 1 second. Now, this letter 79, why do you say that? You want to say that let them go under emergency, emergency acquisitions, you won't need a consent. Are you meaning to imply that? The council?
No.
Then?
It's a different thing altogether.
Why does it say here? See, you're saying this is from... Oh, no, it's from... Sorry, not from you. Right. My mistake. Yes.
So, the Deputy Commissioner wrote letter dated 1st July 2021. Where is that? Yeah, see? And we have responded by way of
where's the letter?
By way of letter dated 2nd September.
Where's the letter 1st July?
Where we have denied.
Where's the letter? It is 1st July.
Lordship, in fact, just got it under instruction this morning.
2nd September, this one. Where's 1st July?
This is a reference to 1st July 2021. This is somewhere here in the petition.
Okay. Is it Chanda? Where is it? 17.
17. 17. I saw this morning.
It's not.
2021, 17/2021. One seven.
See, you come to Annexure 14 also. Reference is to the 17/21 letter. The letter seems to be very important.
86, 88.
See, 31st, page 92.
Yes, sir.
You reference the same letter.
That letter is not part, my lord, of this.
Then where's the letter?
We also, my lord, we have received this letter now.
Then this repression has lost its force.
What we are saying is that under the law, my lord, the district council is not required to, my lord.
Who says?
We are not, my lord.
Only in the case of emergency acquisition. What law says that not required?
There's a provision, my lord, under the constitution, my lord.
Constitution?
Constitution, my lord.
What provisions of the constitution? You take out that the new act, this compensation act. What provision is that? I don't remember.
My lord, section 40 of the new act, my lord, right to fair compensation says, my lord, that NOC has to be obtained, but that is, my lord, in respect of 5th schedule areas, my lord, and we, my lord, we don't fall under the 5th schedule areas.
No, come. Where's that provision?
My lord, if I am not wrong, 41 of section 41, special provisions for scheduled castes and scheduled tribes.
See 41(3). Where's that? The 6th schedule? See, read 3. In case of acquisition or alienation of any land scheduled areas, does not say 5th, 6th schedule, that by concerned Gram Sabha, Panchayat or autonomous councils at appropriate level in scheduled areas under the 5th schedule constitution, as the case may be, shall be obtained. In all cases, in such case, urgency before issue notification. Now 40 is special powers in case of urgency. So you will come under 42 actually. You take instructions. Mr. Vijay Kintalan, Special Counsel KCC, has produced a letter dated 2nd September 2021 today, which indicates that the consent sought for by the petitioner had been refused. Stop. Mr. S. Chanda, correct? Next paraphrase for has allowed 3 weeks time to obtain instructions.
15.
For the remaining respondent, I have received the authorised comments. I pray for 2 weeks time.
How many are there? There's only medical only.
There are 5 lordship.
Then?
For respondent 1, I have filed.
Mr. H. Karmi submits that he may be permitted to file affidavits on behalf of other respondents. For 2 you filed.
For respondent 1.
Then
NHM.
Why do you say that you file in the course of the day?
That one I have filed on the last date, lordship.
And for 1 also you filed?
For respondent number 1 only. I have
1 and
on
2.
the last date. 1.
So why you say respondent number 2 last time?
No, respondent number 2. 1 only, lordship. Respondent number 1 only.
Mr. H. Karmi submits that due to inadvertence, it had been submitted before this court that the affidavit on behalf of respondent number 2 would be filed in the course of the day. But in fact, the affidavit was on behalf of respondent number 1. Stop. He therefore prays in without further 2 weeks' time.
I apologize, Lordship. It's for respondent number 2 only, Lordship.
What is this?
Mission Director of NSM. I apologize, Lordship. I'm sorry.
No.
I'm very sorry, Lordship.
Mr. H. Karmi, Additional CGA submits that he may be allowed some more time to file after we have other remaining respondents. We are allowed this after 2 weeks.
16.
Where's the affidavit? Okay, you're Mr. M. Marwin. Mr. M. Marwin first one submits that the I will file a course of this matter on Thursday for further orders. Thursday is the 18th.
17.
Yes, Your Lordship. May it please Your Lordship. We have been told the instruction is that these people have not been working since March 2022, Your Lordship, February, and till their such time they were paid. Till they were in service, they were paid. These people, this petitioner was actually a muster roll labourer before he was allowed to.
Is that correct, Mr. Nompu? They didn't work in 2020. No, Your Lordship.
As sectional assistant.
Sectional assistant since 2001, Lordship.
Yeah, that they have been working from 2001 on temporary basis.
Why were it discontinued?
Your Lordship, because they were originally, Your Lordship, they were allowed to, appointed on temporary basis, Your Lordship, because of the exigency in the department, and the original sectional assistants had by then retired or died, Your Lordship. So these two petitioners were brought in on temporary basis, and their position, Your Lordship, the original incumbent, theirs was also a work charged post, Your Lordship. It was not a regular sanctioned post.
I can suppose they were working.
Yes, Your Lordship. It
How
was only
possible?
personal. It was only personal to those people, Your Lordship. And after they had retired or they had died, some of them had died, these two petitioners were brought in, and they were allowed to work, and they
How?
continued to work.
How?
Then, Your Lordship, and they were being paid salary, everything. But once the database system was implemented for payment of the salaries and all that, Your Lordship, then their names did not appear in the data.
So they are victims of technology because of your
and then they
because of
could
your
not be
latches.
paid. The salary could not be, pay slips could not be generated, Your Lordship. Now, Your Lordship, what they are saying is that these people have been allowed to, they've been offered to work as muster roll labourers again, because that post was only personal to the original employees, Your Lordship.
But what a section assistant gets and what a muster roll gets is like
It could be different,
It is
Your Lordship.
a difference.
So
between,
they have declined to accept the muster roll labourers
You
because
file
they were
affidavit,
originally
you file affidavit. Let them file, Ms. Nompu.
they were working as muster roll labourers only originally, Your Lordship, before they were
T.
appointed.
Yangi, learned EAG on instruction submits that the pay of the petitioners was not processed and released due to the nature of the employment, which he contends was strictly temporary and against non-sanctioned posts. Stop. She further submits that they have ever been offered to work
As muster
roll
or on
labourers.
contractual basis.
On contractual basis. Stop. Learned counsel directed to file a detailed affidavit. Yes. Within 3 weeks. Let them file.
18.
Because
18.
But these are collective matters, Your Lordship.
Okay. Aisyah parah, dia kata betul sekali. Masih cari so. Yang pokok part kat sini. Finish. Mr. Jindal, you ready with the matter?
Lordship, I am ready.
We will take up the partner matter first. And Mr. Chandrasekhar, the strictly simply, what do you expect? You ready today? It's partner also, strictly. Which was partner first, strictly or this one?
Strictly first.
Then strictly you take up other partner matter first. Strictly, I should strictly. I was just looking which are the partner matters. We take up strictly simply first.
Yes.
Well, he's what? Partner? It's not partner.
Then if
No, I think strictly simply is the oldest one.
I think it may not be possible. Then if Sir agreed, we can take up tomorrow also, Your Lordship. In the first.
Sir looks
first
very
hour.
eager. He's.
We can because two already before us two partner matters. So we'll,
That's what she is asking me whether. I thought that I was under the impression that yours is the oldest partner.
So if Lordship is kind enough, we can do tomorrow, Your Lordship.
Tomorrow, Mr. Jindal?
We can do tomorrow, Your Lordship. In the first hour, Your Lordship. As a first item.
You don't want to make him wait.
It's not that, Your Lordship, because two partner matter are there. No?
It's only 12:20.
Time portion.
Yes. Will then you wait for some time. If the matter takes long, you take a chance or you fix up among yourselves.
Lordship. Apply, Your Lordship.
25.
I'll just come back. Call up 25. I'll just 5 minutes. not attempt to mention, yes.
Because item number 20 and 21 are connected matters, Your Lordship. So after.
You should have mentioned in the morning. Which 2021?
21.
Why you want to take now?
Because the part matter will be taken fast, Your Lordship. So.
That doesn't matter.
Yes.
You're ready with the matter?
Ready.
You're ready.
Mr. S. Day is also.
You should have taken time earlier on. The juniors here shouldn't. If your junior mentions, I can understand. But then, you see, the thing is that there's a very strict. If juniors mention, we can still condone them. As senior
Your Lordship,
practitioner.
I'm not senior. I'm
senior practitioner.
Just in age, Your Lordship.
Just not don't.
Please, Your Lordship. And next week I'll not be here. So.
Just after 3 weeks at the request of the council.
Much obliged, Your Lordship. Highly appreciate.
Your Lordship, I beg your indulgence to mention item number 24, Your Lordship. Mr. Khalid Khan has just left, Your Lordship, because he wasn't feeling well. Otherwise, I would have mentioned it in the morning also, Your
Which one?
This item number 24, my lord.
It's only 12:30 now, actually.
He was here in the morning, Your Lordship, but then he suddenly fell ill, so he left, Your Lordship.
And MS Kolni, Eman Marap is not part heard. It's not indicated here.
However, there was some difficulty.
No, it's not part heard. Part has been indicated part heard. It's not part heard, Mr. Yes.
In Eman Marat, my lord, final gradation list has been circulated recently, my lord, where where the gradation, some of the.
No, Mr. Bura has come forward because this actually should have come in orders. See, the thing is that the list provided by you, there's a total mix-up on the serial numbers.
Yes, sir. We have checked it and we found that there is a mix-up in the numbers. My colleague, my lord, will circulate the final gradation list.
You give it to Mr. Bora. Let him examine it and we'll have it after 1 week.
Yes, sir.
My lord, I'll
you serve it to him, yes.
to the court master.
Give it to the court master and give copy to Mr. Bora.
Yes, yes.
Note down item number 23. Pursuant to the query of the court with regard to the inconsistencies in the serial numbers of the gradation list, Mr. Hamid Kumar with MSR Kolni have produced the corrected gradation list. A copy.
No, but final gradation list.
Final gradation list.
The MPS officer.
Copy of the same is handed over to the court and is made a part of the record. Copy is also handed over to the petitioner. This matter up to 1 week for further orders.
Yeah.
In the order column. Yes. Yes.
25.
Call out, you take a break call off from there, Ben. Huh?
Your Lordship, I beg to mention item 29, Your Lordship.
This is totally out of form. You can't have mentioning twice. Next time we impose heavy cost. And that cost will go to a just cause. You know just cause? 29.
Your Lordship. For the petitioner, my lord, I was informed yesterday.
You have objections?
My lord, she has informed me that on the next occasion they'll be doing it. So for
why is that adjourned in the morning?
My lord, I don't know. Mention was not made. I was expecting that a mention would be made by the respondents.
Yes, the request of the council would respond this matter for 3 weeks. Yes.
Obliged.
Yes.
Item 24.
You mentioned just now, right?
Yes, Your Lordship, but Your Lordship has not passed the order.
24th after 3 weeks, yes.
Obliged, Your Lordship.
What's the matter? Is it Lokyokta matter?
No, Your
No, my lord, it's we're challenging the seniority, my lord. Last occasion also not heard this matter.
Obliged, Your Lordship. 25.
All matters has come for adjournment now. The next one piece will go after 4 weeks or 6 weeks.
Lordship, actually we are ready, actually, my lord.
25.
Yes.
Lord, before I go to the secondary petition, last Friday, Lordship has given patient hearing. I'll just point out one annexures and prayer in my first read petition and go to the secondary petition. Lordship, kindly say I have filed the additional affidavit. my lord, additional affidavit we filed on, my lord, date.
In which one? 172?
My lord. 172, my lord. 172. On 7 February 2023, we filed
On?
After the Lordship has given permission to us. In the paragraph C, my lord, para 5, may I just draw Lordship attention to para 5. He strictly claims that he is a sponsoring body. He has spent huge amount of money. Lordship, can you see para 5? May I just Lordship got it. Lordship, he stated, petitioner begged to submit that the petitioner has spent only in the construction and maintenance of a school building and the land more than 35 lakhs till date. At present, the school needs repairing, extension, and other additional maintenance. He has been spending from the day he took over, my lord. And my friend's side, my lord, headman side, there did not any expenditure incurred by the headman, by the village authorities, because I'm solely running.
You charge fees in the school?
My lord.
Were fees charged in the school?
School,
the whole time you're running it, fees were charged.
Fees are there. School fees are there.
Whose pocket did the school fees go? For the maintenance of the school?
Maintenance of the school, my lord.
Absolutely.
Yes.
And your pay came from the government?
My lord.
Because you're one of the sanctioned teachers.
It did pause, yes. It did pause. And many a times, my lord, even the students are unable to provide obtain the uniform also. They used to sponsor. Basically, in short, may I state that he's a man who committed for my lord, the education in the rural area for the last 30, 40 years. My lord. Now, in the prayer portion, may I just come to draw Lordship attention to the prayer portion of my writ petition, same writ petition. Page number 17.
Page number?
Page number 17. Page 17. Prayer number 1 is to set aside the approval given to my friend's side. It's a wrong approval. No meeting was held. They are not entitled for calling meeting for electing of the managing committee. Now, number 2, prayer number 2 is that, my lord, direct the STSUO to accord or give its approval to the legally constituted new managing committee as contained in the proposal dated 12/2/2020. So my prayer is that once the Lordship set aside the first prayer, if Lordship are persuaded to my lord, then the second prayer would be to direct the STSO to give approval to me. These committees are still there. They are ready to manage the school.
This is 12/2/2023. But now 12/20 is over the period.
But now approval was never given there.
Whatever it is.
Even my lord, even Lordship.
Now what happened there in 2020 with secretaries members? Maybe some of them might have been interested. Someone might have left the planet. Who knows?
So far as instruction received, they are still there. They are still.
Second one's unsustainable. Yes.
In that case,
new circumstances. New
managing committee may be formed. That question will arise. Yes. Now, so the second petition, my lord, I'll come to the second managing committee.
1 second, Mr. Abraham.
Second petition.
Before you go to the second petition, if I make one clarification with regard to that first petition, Your Lordship. Since he's going to second petition, even please take back again that rejoinder affidavit or rejoinder filed by this petitioner into page 4, that is paragraph 5, which my learned senior has
35 lakhs.
That 35 lakhs does not document nothing to substantiate it.
We are well aware of that. But he says one thing, very nice thing. You see that para, read that, what he says first. He has spent only 35 lakhs, he says. See, read that one. See, he didn't say that. What do you see? Read the first line.
The petition begs is somebody the petitioner has spent only in their construction
yes,
and maintenance.
He spent only that much he spent. So for him, the small amount. So he need not be compensated. That's why he didn't give any backup. He just informed the court that he spent only 35 lakhs in the construction of the school. That's what it meant, I think.
Exactly.
Well, he spent only 35 lakhs, which is small change. He didn't say that I spent a huge amount of 35 lakhs, which I need to do. He didn't say that. I spent only 35 lakhs. Yes.
He spent for the construction.
No, that's what he said. I spent only 35 lakhs. So that is, he's not claiming that also.
Yes. Now the second petition, Lordship, kindly see page number 15, the first annexure. In 1986, they have handed over the management of the upper primary school. This is upper primary school. Upper primary school. On the same ground. I will not take other annexures, my lord. He continued to run without any interference by the other side. And thereafter, my lord, page
Where?
Page number.
Secondary petition.
Page 15 of the writ petition. Annexure 1. School was handed over to him by the headman. Page number 15, Annexure 1 in the writ petition. School was handed over in 1991. And continuously he was running without any interference by the local authorities, headman also.
This was the same one, the other one also?
Same one. Now
This is ME school.
This is upper primary school. First one is LP school.
Same letter?
Yes, same letter. Now,
18 March.
Yes. And my lord, we come to page number 40. This was the managing committee approved by the STSU of 2020 for 3 years. My lord, Mr. Simley was selected as a joint secretary, serial number 3. Now this approval, my lord, managing committee of the Morapat Upper Sansat is hereby reconstituted with the following members for a period of 3 years with effect from 1/2020 to 28/2/2023. So this is my managing committee. After they took over, now the tenure is over, admitted fact. My tenure is over without any interference by respondent side also. My tenure by now, it is over.
So this managing committee finishes term?
Finishes term. So it deserves for fresh selection, madam. Now, thereafter what happened, Lordship, the page number 42, these are the inquiry made by the STSU of updating the teachers. Let's continue. Then we'll come to, straight away come to impugned order thereafter. STSU asks for certain particulars. We all furnish all the particulars to the STSU. So STSU was satisfied. He did not take any action regarding that one. And surprisingly, page number 54 is the impugned order. I challenge this one, my lord.
54?
54, my lord. Annexure 11. Now here it says, my lord, under the authority conveyed by White Letter Sunset, that is 7 October 2021, the current school managing committee of the Mauropa Sunset is dissolved today on 10 December 2021. The interim managing committee has been constituted directly over the management and to look after the affairs of the school with immediate effect.
This was stayed?
It is not. It was some status quo order was passed. Status quo.
Then was tried to be misrepresented by
some miscommunication was
friend there.
He tendered unconditional apologies. And Lordship was kind enough to accept his apology. This was this one, and serial number 4, my lord. The headman is also a part. Headman is become the member of the managing.
Doesn't matter. Headman is a headman.
On his complaint, the action was taken and he became the member. Now I challenge this one, and the detailed backdrop of this one is quite revealing in the affidavit filed by the state government. And I'll just draw
in this writ petition.
In this writ petition. Now the affidavit filed by the state education director. Affidavit dated 17/5/2022. Director has
filed on?
Well, as per my record, it is 19/5/2022. Sorry, 19 May 2022.
Yes. What do you want to show?
Now, may I just Lordship can see the complaint, the origin of the disputes. Complaint would be available page number 50 of the affidavit. Page number 50.
Page number?
50, 15. This complaint was lodged on 21st March 2021. It was never served to us. We came to know after receiving the counter affidavit. Now
page
this
50?
Page 15, madam. I'm sorry. Page 15.
In the affidavit?
In the affidavit.
State affidavit, madam.
Filed by
Annexure
Mr.
3.
Ambrose H. Marak.
Annexure 3, page 50.
In this kind of form?
No, madam, I think that is the rejoinder affidavit of the petitioner.
No. And I have to
Madam, in the affidavit of the state, there is no documents that is.
So what is this?
That must be a rejoinder.
No, not rejoinder.
Because the rejoinder affidavit has those documents which are horizontal also.
So you kindly have a look. This is the affidavit. I think it's time to go paperless. Easier to locate papers.
My affidavit, yeah, these are rejoinder. My lord, my affidavit, this is not the affidavit. Lordship is looking at the affidavit of the rejoinder affidavit file.
No, you just see.
My affidavit, my lord, the affidavit of state ends at page 24. Since it's at
Then what page 50 is saying?
This one.
No, he's looking at this one. This one.
Yeah, for this continuation of this one.
No, this is a different affidavit. This is a different affidavit. Yeah, this is the one he's referring to.
Yes.
They are different affidavits.
Now that affidavit, my lord, is filed by the director.
Thank you.
That affidavit.
Okay.
In page 15 is the complaint filed by the local authorities. A detailed complaint was filed behind me. I will not take the. I will not read the entire one. The contain the heading, my lord. Number 1, complaint is low enrollment. And second, dropout of students, my lord. Forget about his own school, my lord. Implementation of scheme, appointment of teachers is a complaint. Inclusion of members of community, utilization of grants.
Where the allegation made against you that the school was taken over by. See, their ground is that this was taken over by deceit, by misrepresentation, that that you shown that it was taken over by you, only that it became all in all. That is what they're trying to show. That the village didn't know is by one single person. Last time said he was a minor and this and that. Will not go into that.
Yes.
That they were all babies when they gave it to school. That is what they're saying. Correct.
Correct. Now, in that first petition, they project that case in that way. Now, in this complaint, which is the foundation of this secondary petition, there is no whisper that I took over the management of the school. It is not there. Here, his primary claim is that I mismanaged a school, low dropouts are there, implementation of the government grants are not as per the norms. These are the general complaints. On the basis of this complaint, my lord, the next page number 19, my lord. This letter was issued to the director. Complaint was referred. With reference to subject cited above, I have the honor to forward here with a copy of the letter from the third party as under reference, requesting the dissolution of the school managing committee. So he has referred this complaint to the director. The thereafter page number 20, order was passed in charge deputy director. Page number 20. It says dissolution of school. It says, with reference to subject cited above letter under reference, I am directed to instruct you to kindly carry out an immediate spot inspection in view of this reason mentioned before any other course of action can be recommended. So this was the letter issued. And in pursuance to this, page number 21, madam, this letter was issued. We never received this one. It says, with reference to subject cited above, I have the honor to inform you that authority will conduct a spot inspection on the matter related to dissolution of the school managing committee of Sun School on 13 August 2021. In your school, positively, all related documents, records pertaining to your school should be made available on the said date for the same. This letter was never served upon us, and thereafter, my lord, they came for the inspection. They informed me over telephone. They were in the headman house, and along with the headman, they came to my school, and the inspector asked me to produce all the records.
You were there. You were there also.
I was available since I received the telephonic communication. Then he said that you surrender the management of the school to the authorities. So this was the inquiry came, and the report was made, my lord, 21 August. It says submission of special impact report on such. Now the day report is my page number 23. Page 23. The day report is there. Now regarding low enrollment, this is the finding. My lord, your students are there. This is pandemic time. And low drop of students. There is a lack of coordination between village administration and the school managing committee, which just result to drop out of students, and the school do not have any record of students, and there is no following up in case of dropout existing. So this is the finding of the authority. Implementation midday meal scheme. There is no record of the implementation midday meal scheme for many years, where the number of students beneficiaries not known. No midday meal register is accordingly maintained by the Secretary of the MC. The school did not serve midday meal regularly, and accordingly, it was noted that the SMC had removed a lady cook cum helper without intimation, and in her place, they appointed as the president of the managing committee to be the new cook helper, my lord, which record they available, my lord. Implementation of grant in aid. The school does not have proper records in the implementation and utilization of grant in aids, salary of teachers. There is no cash book maintained by the secretary of the SMC. The disbursement of salary and implementation of the schemes allotted against the school was not clear. Appointment of teachers. The school did not maintain the record of the procedure for appointment of teachers. It is evidently found that the teachers are appointed without prior approval of the concerned authority. In the letter, as mentioned by the president of such and such, there is none payment of salary of teachers, namely such and such, and such and such. As per the convention conversation made between them, it transpired that both the teachers had been removed and the disbursement of their salary should not be questioned. It was found that 2 teachers had been removed without any intimation and prior approval from the concerned authority. May I just point out here, my lord, these are the temporary appointees, temporary basis. They are not receiving any grants also. So this is one of the findings. Inclusion of members of community. Morapar Sunset falls under the jurisdiction of Morapar village block. It has been found that there is no representative from the village Darbar that included in the school managing committee as per such and such. So this is one of the complaint. Utilization of grant and aid. The utilization of grant and aid in the school did not give clear picture to the secretary, and the president did not cooperate with the concerned inspecting officer. Poor hygiene, the school did not maintain proper sunset. So this is on the backdrop of this complaint, my lord. Behind my back, they issue the impugned order and stopgap arrangement managing committee took over.
Why behind your back? You were there for an inspection.
My lord, now I'll come to the Meghalaya Education Act. Where is it?
We will not go to the act. You cannot hide behind the act. The thing is that, Mr. Changre, so the very good that action was done without proper prior intimation to you. Because that means the dismal state which the school is running, you appoint temporary teachers, use the money, throw them out.
No.
You don't, that's the thing, the hygiene is bad, even nothing grant in aid house use, you don't know. The school doesn't have proper records, employees are utilizing grant in aid, salary of teachers, there's no cash book maintained at the school. You've appointed yourself as a cook. What more sadness can be there in that school? If the school is being run as a fiefdom of one person, he cooks, he says, he's a cook also.
No. That is not correct. That is not correct.
No, appointing the president as a cook.
That is absolutely wrong. There's nothing on record that the president of the managing committee was appointed as a cook. That is irrational at all. On what basis they found that?
But it's signed by the sub-inspector of schools. He's a SEO,
my lord,
a responsible officer.
Therefore, my lord, I'll give lordship pay your lordship attention.
And if on disputed facts, then we'll order for inquiry.
We are most welcome for fresh inquiries if lordship deem it fit.
But then now it's too late in the day, my lord, because this is 2021.
My lord, therefore, lordship can see my
now the school being run by the
ad hoc committee, which is
under the has enrollment increased?
My lord, that some
they are not, my lord. Therefore, I said the managing committee of my friend, they are stationed in his own dissolved school, managing committee at the school. They are sitting there. All the MC members are sitting there. They never come to my school till today.
My lord, the exact
and they say
number,
that you come.
The exact number I will not be able to place unless I take. But I have been informed number of students have increased after the officers. My lord, this was after the hearing stage. This question was raised. So at the time of filing the affidavit, the question of number of students was not raised.
See one thing, Mr. Chariso. Yes. They always say that there cannot be any smoke without fire, right?
My lord, but definitely.
And then if the inquiry report, the complaint was there on these points, fact-finding inquiry was gone into, and they found this thing. It doesn't mean that your school is as pure as snow that's running. That you're a model, you're a model secretary, that you've run the school, to such exacting standards that that there's no fault. Now these things are writ large. Now what is your claim? Now you've retired also. Now on what basis are you seeking to sustain your claim that these schools are mine?
I'll come to that point.
Give me one case in the entire Khasi, Jaintia, Garo Hills where a school of the village is handed over to one person who runs it for a period of 30 years.
40 years. Yes.
Give me one instance. where one person's run it and then, use grants and aids, appointed. Give me one instance. If we cannot feed on egos, that this person's been given a free rein. This is the tentative view of the court. He's been running a school. How the school is handed over? There's nothing registered. Nothing. There's no bar resolution. Nothing. There's only one headman whose signature is never verified that I hand over the school. Maybe at that point of time, they were too illiterate, they were too oppressed or depressed that they cannot be able to run a school village. So you come along, you're a smart man, you run it by yourself as your own fiefdom. So see, those are the things that, is a common sense that you look at in the bundle of materials on record. And then you run it and now you're retired.
Yes.
1P is still maintaining, and then now even after retirement, you're not supposed to teach anymore also. You want to hold on to that power. You're deriving so much benefit from this.
My lord, these are the possible questions, lordship.
They're not possible questions. These are only things. You have not been able to satisfy this court even little bit, Mr. Changreso. As to how can you substantiate your case that your school has been handed over to you? I've been running it. I am the sole sponsoring body. I am the only person who appoints the whole managing committee. That is nowhere. There's no involvement of the village anymore. You're running it like your own, it's like, not that I'm saying anything to you, but from what appears.
My lord, it is my duty to.
And that's why when the inquiry, when they found all these discrepancies, and even then you say behind my back, but you were told, the very fact that you were told that they were coming for inspection speaks a lot about the fairness that was involved.
My lord, we will look to the provision what the law provides.
We're not going to look to the law here.
We're not looking to the law. There is a provision, my lord.
No.
Where it provides the
you challenge it in appeal. You challenge appeal. As to manner inspection was done in a proper manner. But when it involves a community versus one person, then the whole parameters change.
My lord, therefore, they handed over the school to me and running for 35 years. If I fraudulently, by application of fraud, misrepresentation, my lord, took over the school management and run the same school in the same village for 35 years.
No, Mr. Chandra, we're saying that time they were depressed. That was 35 years ago. They handed over the school. But later on, how you ran it, that came to question.
My lord, if I took over the management illegally, my humble submission.
There's no question of taking illegally. How you took over the school, there's no resolution, nothing. Maybe at that point of time, he had been friendly to you, take over the school.
No. My lord, if that be the case,
maybe we've gone beyond the scope of the writ petition, but just to the story that comes out from here is like that. That is, you're very smart, the school is depressed, the villagers are illiterate. They said, please look after the school. And once you got a chance, you went upon your own family members, I think as managing committee members, ran the school, threw out teachers, appointed teachers, used the grants and aid, appointed a sanctioned teacher, one sanctioned teacher, so you're deriving great benefit. And these poor people, they don't know better because there's no one smart enough to stand up and say, I think what's happening is not correct.
Lordship, it is my duty since I wrote that.
And one thing is that you must remember, you've retired now.
That is true.
What do you want?
But therefore, my
what do you want now? You've retired. Whatever management committee you propose, that term will never, it's 2020, cannot be acted upon. Even the second one, nothing. In both petitions, where do we stand? You are saying that dissolve the other management committee and approve mine, which is constituted on 12/2/2020. Now it's beyond. We are 3 years down the line. Now that is gone.
Yes.
Now this other part is gone also. This other. Now you are retired. What do you want? Just tell us what do you want?
No, my lord.
What do you tell the court exactly? What do you want?
My lord. My humble submission is that, my lord.
Beyond the prayer, what do you want? You want to take control of the school again. That's what you want.
Lord, it is not the matter. We hire with profound respect, my lord. Since I invoke the jurisdiction of this.
Wait, what do you want?
It is my duty to satisfy, my lord.
No. What do you? No, I don't want to satisfy. Tell me what at this stage.
Right.
What do you want,
my lord? My humble submission is: it is not the case of what I want, but it is a case of the rights of the petitioner deprived by the action of the respondent.
That is right. What do you want now?
No, therefore
what order you want? What do you want now? If you feel by setting aside orders, where will restore you?
Now, my humble submission would be, in view of the subsequent development that take place down the line 3 years now. Now, the managing committee which we formed earlier also stands vanished due to efflux of that.
Yes.
Now, what the prayer made by the petitioner would be that they set aside the impunity action taken by the respondents and direct for a formation of a fresh managing committee.
By whom?
My lord. Therefore, the question is, the sponsoring body, relevancy of sponsoring body comes into picture.
You're retired now, you're nobody.
No, my lord, sponsoring body doesn't depend on my employment. It depends
you're
on my
nobody.
goodwill.
You're nobody now, you're retired, you're only able to teach also. And you want to be the sole sponsoring body again.
My lord, I've done some...
Is that what you want, Mr. Changreso? That by virtue of, I want to be sole sponsoring body, that is your case. That the village has no right anybody to interfere.
Yes.
That I am the only man, I'll run the school. Notwithstanding anything the authorities say.
Right.
Is that what you want?
My lord, the school...
Now you just put yourself in the school. Is that what you want? Can the court give that order?
My lord, according to me, my lord, lordship has enough power to give this type of, grant this type of prayer also. I would understand, my lord. They have seen I made a huge investment. Lordship has pointed out, I only use the word only, 35. Now, if they take over again, okay, you are running the school for 35 years, 30 years, you have incurred some expenses, we are repaying to you some token amount and restore back the management to the authority.
You've drawn the
that is one way.
You
One
must
way of
spend
taking over.
10% of that money.
One way. But now, after 35 years, they woke up and suddenly took over. My lordship, before I take a lordship attention to the rules, to the act, may I just draw attention to the rejoinder affidavit filed by me, reporting the findings made in the inquiry report, madam. Detailed affidavits, madam. Detailed documents I have annexed.
We're not interested in going to fact-finding thing. This court will not go to disputed facts. Whether the pot is black, found in the kitchen, we're not interested. The only thing is that the inquiry report may be wrong, it may be wrong. It's brought up something. The only thing is that the court wants to know, what do you want now? You want a finding that you are the sole sponsoring body and shall continue as such.
But sponsoring body has a role to play for formation of managing committee.
Right. You think you're a sole sponsoring body.
Yes.
You're the one-man sponsoring body, correct?
Yes.
That's it.
Yes.
But the school belongs to the village, correct? No. Now, what was the price of the school when they gave it to you? It was 35 lakhs.
No.
With the land, with the school.
But with the land also, my lord, I purchased the managing committee.
From your wife.
From my money. We purchased.
From whom?
My lord. That is
from whom do you purchase?
My lord, what happened is that
another lady. From whom do you purchase the land?
My lord, we purchase
from
my missus. My missus purchased from another person, and thereafter the school need the land. Therefore, as a managing committee,
very peculiar
my lord,
case.
Managing committee purchased the land from my missus. In fact, it is my money only. And
how
construction,
old,
my lord.
Is Mr. Chikri's Imlia now?
My lord, now another aspect, my lord, the construction of the school building, management throughout, my lord. He spent all.
But understood now. Understood. That's understood. How old is Mr. I want to. This court wants to see him, wants to see his face.
Well, lordship, we call the DSEO also, headman also, they can come in and pay before lordship also, they can, lordship may see also. Now, therefore, the rules, my lord, the Education Act, my lord, everyone, my lord, are functioning under the Act. Now, I'll point out two sections of the Meghalaya Education Act, my lord. How inquiry has to be conducted, the manner in which how the government can take over the managing committee and so on.
Because what do you want now?
Education Act. Just lordship kind. I first flag lordship kind.
The first flag. In the end, you see, so why this court making all these observations? In the end, it's the children who suffer. That's why.
That is why, my lord. That is why, my lord. That is why.
That is why.
But here, my lord, therefore, we are saying that the school managing committee, the headmen, village authorities, they are not interested for this matter. But the private respondent who became the headman recently, he established his own school and failed himself, and he took over.
Mr. Chancellor, I'm not saying they're angels also. No one's saying that. Just saying the conduct of the petitioner, the conduct of parties, whatever. And if the orders that have come, and it's the duty of the government to ensure that there's some order and some semblance of, where.
But first flag, my lordship may this with section 20, taking over the management of schools. The first flag now. It says, whenever the government is satisfied that the managing committee of any school, whether recognized or not, has neglected to perform any duties imposed on it by or under this Act or any rules made thereunder, and that is expedient in the interest of school education to take over the management of such school, the government may, after giving the managing committee of such school a reasonable opportunity of showing show cause, my lord, against the proposed action, take over the management of such school for a limited period, not exceeding 3 years. Whenever the management of any school is taken over under such, every person in charge of the management of such school immediately before its management is taken over shall deliver possession of the school property to the government or any officer authorized in this behalf. After taking over the management of any school under this section, the government may arrange to manage the school through any person or officer authorized by the government in this behalf, hereinafter referred to as authorized officer. Where the management of any school has been taken over under such, the managing committee of such school may, within 1 month from the date of taking over, appeal to the state management, who may, after considering the representation made by the managing committee, pass such order, including in order for restoration of the managing committee or for the reduction of the period during which the management of the school shall remain vested in the government as it may deem fit. Well, my lord, may I not come down to the detail? Well, then I'll come to the second flag mark. How the inspection, my friend respondents say that they have done a fair inquiry, and the result of the inquiry was...
No one says fair.
My lord, I say that it is not a fair inquiry.
Doesn't say it's fair.
My lord,
not a fair inquiry. You never again hearing.
My lord, second flag mark, my lord, section 24. My lord, please read with me, my lord. Yes. Every recognized school shall be subjected to inspection as may be prescribed. The director may also arrange special inspection at any school of any school on such aspect of its working as may be from time to time be considered necessary by him. The director may also give direction to the managing committee requiring the management to rectify any defect or deficiency found at the time of inspection or otherwise in the working of the school. If the managing committee fails to comply with the direction given under subsection 3, the director may, after considering the explanation on report, if any given or made by the managing committee, take such action as he may deem fit, including stoppage of it, withdrawal of recognition, or except in the case of minority school, taking over the management of the school under such. But this is a fair procedure, madam. Fair procedure. Now here, madam, this rule was not adhered by the respondent. That is my case, madam. If I give a proper opportunity, give me an opportunity to explain. I am accountable to the government.
So now we give you post facto hearing, you will accept that? Post decisional hearing?
My lord, that is, lordship discretion is so vast that the lordship can mold the relief.
No, I mean, we give you post decisional hearing now. You say, okay, fine, this has happened, but then already under the bridge, managing committees also cannot be resurrected because the terms have already since expired. So we'll afford the petitioner post decisional hearing, and after that, inquiry will be gone into. Afterwards, what are your rights? Your rights, the court cannot discern now. What will be your surviving rights? At right time maybe, but now, what will your surviving rights and what prayers are entitled to?
This is a new question posed to me, my lord.
Because that's the thing. Because the only thing we can say is fine, but there might have been some irregularities in the manner in which the. Please cut it out.
So I'll get attached.
What is he doing? Yes.
This is one of the, my lord.
No, this court is not made up its mind at all. Only thing is that this court understands that, okay, fine, but what relief will entitle now?
My lord.
We look at that only.
My lord, I do admit, my lord, down the line 3 years.
No, down the line. Now you're tired. You've run the school for 30 years. The managing committees have gone. You're saying it's not done in a proper manner. That also, if we set aside inquiry, also, what's the point? We can give post decisional hearing.
Now the rule is very clear. Very clear. They are the author. Responding to the author of the rules.
We will accept that. Okay, we accept that. The rule is very clear that you should have been given. There's a proper procedure laid down. Should be given show cause. Now we'll give post decisional hearing.
Well, given me a opportunity to rectify it. If I fail blatantly, then they can take over.
There's no question of rectifying now. The time's only gone. Post decisional hearing means you see at that point of time this happened, that, so and so and so, and let them take a decision.
The fresh inquiry.
Whether your school is. What is your position?
Well, without prejudice to my main prayer, may I bow down and pray? Well,
there's no main prayer any longer.
Well, regarding the post-decisional or the compliance to the act, which we read out together, well, may I just take instruction from the party and make up on Friday regarding these aspects only? Well, because my prayer should be also reasonable. since I want to invoke the jurisdiction of
Charak,
this
so
one.
as a senior counsel, you are well aware. Now, when the circumstances change, how you always seek from the court to mold the prayer, and then you mold the prayer, and then the court also to mold the relief.
That is true.
That may be available to the petitioner at the stage. That's the only thing. But if you cannot change your prayer, if you cannot mold your prayer, or you cannot, then what remains? Remains to say that the cause of action for which this case arose was, this. I'll just give the text of the order that had come, has already elapsed with time. The only matter that arises is a question of grave disputed facts, especially handing over, for which it will be a matter of civil dispute. That now we relegate the petitioner to seek alternate remedy by filing a suit to seek his title and declaration over the rights that he was handed over to school, so and so. Documents have to be proved, evidence has to be adduced, witnesses have to be called. So you'll be, I think you'll be gainfully employed in doing a title suit for next 10 years, 15 years. But that is what's forthcoming.
Therefore,
that's why this court trying to help you say, okay, the regular post, but that's the thing. Otherwise nothing remains.
Therefore, to satisfy the conscience of Reed Court, Lordship.
No conscience, there's no conscience. We're just here to do justice.
The task is, my Lord, very huge for me to satisfy, my Lord. No, otherwise, Lordship has seen.
Otherwise, you go to civil court.
There's a blatant violation.
You go to civil court. That we can overlook. You can go to civil court with regard to your question of title over the school, and that those people have assured advice anyway.
But in fact, one aspect also, my friend is not also claiming that we are the owner. They said we have the right to participate in the formation of the managing committee.
Then you have
so title of the school is not at all disputed by my friend also. Not by the government also.
You can file a sort of permanent injunction also.
My Lord.
That I am the one that they permanently injunct them from taking part in the management of the school. Since you've handed over to me.
The dispute is
okay. Let's not go to the title of the land and of the school. You can go.
But the dispute within the parties here is a management, not with the status of sponsoring body or the ownership of the school.
I'm sorry, a lot of court time has gone, but nothing has emerged.
My Lord, this is my humble prayer.
Very peculiar, interesting case.
Therefore, my Lord, see the conduct. My Lord, I have to satisfy myself also, but other side to look, my Lord. Number of headmen, one after another, they come.
They have to prove that exactly. I'm not ruling in their favor that you should be kicked out immediately, let them run the school.
When the private respondent comes, my Lord, then the problem started, my Lord.
There was one case, which, just off the record, which I had occasion to do as a lawyer. Same thing. There was a lot of wrong things going on in one village. And there's a certain section who are very oppressed, even with regard to allocation of community land, with allocation to other benefits and all. One section, because they form only a small majority of 15 or 20 households. And they kept quiet. They were made to cultivate in the fringes of those fertile lands because majoritarian rule. Correct? Then so happened one family, one young man married into one of those families. And when he married to a family, he saw that, what is this going on, Why is the majority, why are these sections being subject to this? He came to court. And as a court, he narrated to me. I'm very disturbed. He's more intelligent. How can this happen? On what right are these other families doing this to them? Then the question was put, same as but there's a bit going on. That is what's happening in the village. But when we filed one case, whatever, the whole thing unraveled. So much so that a sitting judge of the High Court went for personal inspection to see the conditions. And this fellow, I tell you, I was so impressed with him. He was maybe illiterate. He looked unwashed. But when he came to me, his eyes were shining with intelligence. And he was narrating to me that this cannot go on. He said, I'm just, in Khasi, did you marry, they go to another village, he goes. He said, this cannot go on. Why are my in-laws and other being subjected to this? So on that, then there comes a thing of restoration of rights again. Then there was an inquiry done by magistrate inquiry, so on and so forth, and it's found out that, why? Because people were holding a portion of the land which the village wanted. They wanted their pine groves and all. So you see, that kind of litigation doesn't mean that just because you're silent, he comes after a long time. Maybe he saw something wrong. We cannot say that he saw it. That's the thing. The court has to listen to that also. Like suppose that boy never landed up there, they'll be still living in the same condition now. Maybe they might have migrated.
But that could
like
be
they say also,
Right.
suppose you see majority of democracy, suppose you say that in the village, like 99% of the people say that this lady is a witch, should be burnt. Is that correct? She doesn't have any rights. Then I don't know why I'm lecturing so much.
No.
But this is one case where it's peculiar in the sense that it's the assertion of rights, and the right of the basis of the right is not clear.
But this is one of the unique cases where my lordship has paid so much attention and time.
Yeah, because there should be.
Even this
it's for a
matter,
community, it's for the children of the village. That's all.
Therefore, my
That
lord,
early case was
even this
narrated.
case-
That's exactly what happened. Now,
another option is, my lord, look into the matter. My lord, even the lordship may conduct a direct for magistrate inquiry to find out the truth also.
no magistrate inquiry. This is a question. This is by when you make up your mind. We've done enough. Wasted enough time in this matter. Not wasted. It's a learning experience for me also. Yes.
We come up on Friday, my lord, regarding the
You
respect.
won't come up on Friday, Mr. Changri. So
Or next week, anytime, your lordship, whenever.
we'll fix it.
Like convenient.
Matters remains part heard. This and so and so. Yes.
Lordship, in this matter, I have conversed two issues. One relates to regularization and the second relates to equal pay for equal work. Both these issues are distinct issues.
Now, if I recall, Mr. Jindal, the only hurdle in your way is the advertisement against which you were appointed.
Yes, Lord.
That court wants satisfaction on that.
Right, Lordship. I come to that.
Yes. Correct, Mr. Shulai?
Yes.
That is your ground also.
If Lordship, if I pray,
15 minutes they can finish.
Can be taken up tomorrow
Second half.
in the first
Second
half.
half I'll finish.
No, second half.
He can reply tomorrow.
Second half will finish.
Yes.
You can finish 15 minutes, Mr. Jindal.
No, 15 minutes I cannot.
So that if tomorrow, Your Lordship, kindly, Lordship, in the first as a first item, Your Lordship, tomorrow.
One point is at federal court. One point.
I'll clarify.
How will you, otherwise.
How I'll deal with the advertisement, Your Lordship, I'll
That is what,
satisfy.
at that point then.
I'll satisfy.
This is matter tomorrow.
As a first item, Your
As a first item, Your Lordship.
What hurdle comes first item?
Lordship may say it because otherwise I had to keep on sitting as a first item. Otherwise, I will also forget the things.
You don't forget. No, you're very
Lordship,
sharp.
I'm becoming
We have
old now.
Not old. We have high regard. That way, even I am forgetting everything.
So, Lordship as a first item.
Yes, yes.
As a first.
Documentary list.
Apply, Your Lordship.
Yes.
22.
Where's Mr. Nyota?
Yes, Lordship. Lordship, this writ petition was filed by the petitioner because she was not getting her salary, she was not paid.
It was remanded back from division bench, correct?
Yes.
To the hearing.
What you say?
yield to the hearing. But
If you want to take them, then-
Mr. Qureshi used to appear. I think perhaps my friend is ready. My friend is ready to conduct the argument. Mr. Siddiqui is also there for other respondents.
Where's Mr. Siddiqui? Where's Mr. He doesn't come now. He argues from the comfort of his living room or his office.
He always argues from there. Today, luckily, I saw him here too. He just went out.
Oh, that Moshimara Begum.
Yes,
She
yes,
went.
Your Lordship, yes.
You didn't make her party. Then she went for appeal ex parte. Then the matter was remanded.
That is the matter, Your Lordship. No. No, for me, I am getting my salary, the arrears that has been paid. There is no grievances anymore from my side, Your Lordship. The affidavit which they have filed from both the side, that the petitioner hearing is social studies holding the post of.
You're getting
as a
paid
teacher.
now. Now
Yes,
also.
getting paid, yes.
Who's
And-
appearing for Moshimara Begum?
I'm appearing
for her.
Mr. Samuel Islam is appeared by Senior Counsel, Mr. Siddiqui.
So you still have something to say? Anything to say?
He is the main person. He is the main person.
My post is.
You withdraw the case then.
No,
Let them.
that's why my case. No, Lordship, no. Because language teacher only for them, but me and my post is social studies. It's not in dispute.
Okay, we'll have it. Then it'll go to after 3 weeks.
I'm deprived of the salaries for the last 5-6 years. If Lordship make an attempt after a week or 10 days, I'll be grateful.
Let's see. No, sure. Yes. List on so and so. Due to absence of Mr. M.F. Qureshi for the.
No, Lordship,
Oh, he's come as if by magic when he heard his name. Okay, oh no, sorry. Then Mr. K. Chisa participated at the matter as.
For still respondents.
Yes, who's absent, you said?
I'm for number 7.
Due to the absence of Mr. S.E. Siddiqui. He's the main contesting respondent.
28? 28?
I do.
This matter is rendered infructuous. What happened in this matter is, my lord, we came challenging the order which allowed the amendment of the condonation of delay application. Now that application itself
been rejected,
has been dismissed for on default, my lord. So nothing survives. I'll just hand over a copy of the order.
Your Lordship, we are no longer the counsels in this matter anymore, Your Lordship.
Doesn't matter, it's still revision. Mr. Philaman Nombri, learned counsel for the petitioner, submits that the matter has since been rendered infructuous, as much as the condonation application, which has been allowed, to be amended.
Yes, my lord.
Has since been dismissed for default. Copy of the orders dated 12/10/2022 is made available to the court. It is noted that the petitioner before the court below was absent for 7 consecutive days. That is the matter stands closed as infructuous. Copy of the order dated 12/10/2022 is made part of the record. That's it. So, it's always like that.